welcome everyone. We'll start with an introduction of BCLA. My name is Oscar. I am the current president of Biotech Connection Los Angeles. We're a nonprofit, student-led organization that that aims to inspire, educate, and connect emerging scientists with the pre-existing biotech ecosystem in Los Angeles. The people who are doing this are primarily grad students, undergrads, postdocs, as well as some early career professionals from institutions across Los Angeles. So at the bottom here, you can see some of the institutions that are represented in our team. We're almost 35 people at this point, and we put on all sorts of events ranging from, somewhat formal to internal team bonding events at Topgolf. So the type of events we put on for the public fall within one of these three bubbles. We try to educate. We do this by putting on seminars such as this one, or recruiting panelists for discussion, career development workshops. We also try to inspire. A lot of our events are focused on entrepreneurship and starting companies out of your PhD research potentially. And so we try to platform founders to share their stories and possibly connect with other aspiring entrepreneurs in sort of mentorship opportunities. What BCLA has done most of, though, are to connect. And so our kind of bread and butter events are networking mixers in person, happy hours. We have an annual career fair in February. We also host our largest event of the year in October, which is going to be our Biotech Summit, where we also offer mentorship sessions. If you want to learn more about BCLA, possibly join the team, or just kind of stay up to date with our newsletter, you can go to bcla.org, subscribe to the newsletter there. We usually share our event recaps as well as upcoming events. We have a job board, a podcast. We have a lot of events. With that, that brings us to today's event, Pathways to Immigration for Scientists. I am very happy to be joined by Adam Cohen, who is a partner at Siskin Susser. Adam will also introduce himself, but I just want to start with saying that Q&A is highly encouraged. If you have questions that pop up throughout the event, please feel free to just drop them in the Q&A chat box. If we're able to, we'll get to them during the actual presentation. Otherwise, we'll save them for the Q&A section afterwards. Another kind of reminder, there is some issues with asking too personal questions, confidentiality and such. And so try to keep questions quite general to begin with. And if you're interested in more personal advice afterwards, you will be able to contact Adam after the event. And with that, I'm going to stop sharing and hand it over to Adam.
Thanks, Oscar. I'm going to share this real quick, and let's make sure everyone can see this. Oscar, you see the main screen on this one?
Yep.
Perfect. Thanks so much. Well, great. Well, I'm so excited to be with you all. I really great thanks to Oscar and BCLA for inviting me here to speak with you all. I'm really looking forward to it. Our firm actually has presented to BCLA before. I think it might have been a year or two ago, actually. So I'm delighted that you all have invited us back to chat with you again. I'm going to try to go for maybe about 45 minutes for the presentation, but I definitely want to leave room for questions. And as Oscar was saying, just drop some questions, your more sort of general questions into the chat. And if I see them or Oscar sees them, I happen to be on that slide, we can see if we can just address it at that time. Otherwise, we can just move forward and address them all at the end as well. So what I'm going to chat with you all about today is pathways to immigration for scientists. Really love these types of presentations. I do them in academia, science, healthcare, other industries as well. And it's a great opportunity for me to talk with you all while many of you, most of you, are still early in your career pathway, right? You're either students or you're early career professionals. And so it allows me to just talk with you about different milestones and decisions you'll have to make along the way. It allows you to take ownership over your immigration journey, and become more powerful with the knowledge of how how immigration law and the system works. So, with that said, I will tell you a little bit about myself. And I had mentioned that, I do some work with healthcare professionals as well and researchers. I kind of work in that sort of summit, I guess you could say, between students and academia and healthcare as well. I would also flag for you all just a couple of roles that I have in addition to being an immigration attorney, is being on the American Immigration Lawyers Association case assistance committee. So we have opportunities to liaise with U.S. Citizenship and Immigration Services on that basis. And also I work with NAFSA, Association of International Educators, and also another volunteer role with the Regulatory Sessions Working Group. NAFSA, you all might be familiar with the name, or if you're not, many, for those of you who are students, it's your DSOs or your responsible officers if you're in J1 status. They're also, oftentimes scholar advisors for postdoc researchers at universities or faculty or things of that sort. So I have a role with them. It's, liaising with Department of Labor. So it's helpful to kind of just be aware of what the issues are. And I'll try to flag things for you all as we go along. I'm also author of the Academic Immigration Handbook, which is basically a treatise on a lot of these issues that we're going to discuss related to academia. So with that said, let's go 10,000-foot view on US immigration, right? Because before we can narrow down and really just talk about pathways for scientists, we really need to get out of the weeds and into the grand scale of things. Because many of you will pursue these pathways that are unique to scientists, but also many of you may find that you might be eligible for other types of benefits. And it's never a bad thing to just understand how the immigration system works and what types of categories are available. So first we get to non-immigrants. That's probably the one that many of you are most familiar with at this early time in your career. Non-immigrants are those alphabet soup of visas where somebody is coming to the US for a specific purpose. Maybe they're a visitor for business. That's a B1. Maybe they're in F1 status, right? Students, many of you. J1 also has a student category, but it has other exchange visitor categories too. H1B is the most common professional work status. So we'll talk about those and we'll talk about others. That's the non-immigrant side. It just kind of moves along as you move along in your career, because many of you who decide to stay here will one day want to become lawful permanent residents. You'll one day want to have that green card and have a little bit more permanence in this country. And that's something that a green card can supply. And then one step up from that, you could say, is US citizenship, right? And that's the opportunity also to vote in US elections and to have that say in the governance of this country. And, also having lengthy periods of time outside of the United States without disrupting your status in any way, because that can happen with a green card if you can abandon the green card by being outside for too long. So it's just additional protections that come with citizenship, and it's very hard to become denaturalized once you have acquired US citizenship. Now, on the margins, we have these other types of humanitarian status, as many of you probably familiar with applying for asylum or refugee status. Temporary protected status is for those individuals who, their country has been specifically designated by the US government due to civil war, natural disasters, things of that sort. Then you have deferred action for childhood arrivals, the DACA. Many of you are familiar with that just from the news. These are all sort of humanitarian types of statuses. And I've had plenty of professionals, healthcare workers, researchers who may have a status, but they may also have temporary protected status. They might have a pending asylum application, right? And so at our firm, that's not my area of expertise in terms of asylum and temporary protected status, but we're fortunate to have a lot of different immigration attorneys, and some of them do focus their practice on these more humanitarian types of processes. So we can accommodate that as well. Those individuals, who do not have any type of status, or maybe they've overstayed their status in the U.S., they're known as undocumented, and they have a very difficult path in the U.S. From there. So it's always very important to maintain one's status. There are also multiple government agencies, which is kind of makes immigration law really one of the hardest areas of law to practice, because there's so many government agencies weigh in with different types of policies. You have sort of the Immigration Nationality Act, which is this basic sort of skeletal framework legislation that's existed since 1952. But all of these agencies come in with their own types of policies, guidance, regulations, et cetera. Department of Homeland Security is the main department that deals with immigration, but you have U.S. Citizenship and Immigration Services. They deal with all of the benefit applications. For those of you who say, I want to change my status from F1 to H1B, they handle that. They handle green cards, they handle citizenship. Immigration and Customs Enforcement deals with immigration enforcement. They're also staff sort of the prosecutors in immigration court cases, but they also maintain through their subcomponents, maintain the SEVA system that many of you might be familiar with if you're in F1 or J1 status. That's all governed by ICE. Customs and Border Protection staffs all of the ports of entry, air, land, sea. They deal with admissions into the U.S. Department of State deals with all of the embassies, the consulates, all of the visa stamps that you get in your passport, okay? They deal with that. They also manage the J1 program and J1 waivers as well, which we'll address a little bit too. Department of Labor is concerned with the interests of American workers, okay? So they have a role to play in H-1B status. They have a big role to play in certain perm green card processes, for example, most of common employment-based process. So there's different things that need to be filed with Department of Labor. And then Department of Justice manages and staffs the immigration courts in this country, and also is involved with certain civil rights issues, unlawful discrimination based on national origin, and things of that sort. So we've gone 10,000-foot view, and now I want to narrow us in a little bit to talk more about specific options for scientists. And we're going to talk about these over the next few slides. F1 status we'll talk about, and we'll talk about J1 status also, which is student status, but it's more than that. There's a lot of different categories of J1, which we'll discuss. Then we have our post course of study, processes and visa statuses like H1B and H1B1 and E3. Those are nationality specific statuses that function a lot like H1B, professional worker categories. H1B1 is for Chilean and Singaporean nationals. E3 is for Australian nationals. We'll talk about some of these other, O1, E2, L1. I'm going to leave that for a more detailed discussion. And I'll flag also that TN status is also nationality specific. It's for Canadians and Mexicans. The link I'm providing below, for those of you who are more visual learners, you might be interested in some of these resources that USCIS has put out, which does a pretty good job. There's a pathway for STEM professionals, and it's a lot of the things that we're talking about. They're noting a lot of these statuses, and you can read about it. So I would definitely recommend taking a look at this. You could also maybe Google maybe STEM professional pathway USCIS, and it should take you to this very same link. And if you have any, I'm going to move on to the next slide, but if you all need this again, I can definitely circulate the links to Oscar. So let us move along to F1s, right? Because many of you are starting in F1 status, maybe not all of you, but many. And this is a life cycle. It's not just specific to scientists exactly, but it's for all F1 students, just to realize, what are these different points at which work authorization comes into play? Because work authorization There's specific work authorizations associated with the F1, and they just kind of look different depending on where you are in your course of study. So the first 9 months is just on-campus employment. And then we move on for the rest of the program, the course of study. You have curricular practical training, which is really the most common type of training that is received during the course of study. SEH, special economic hardship, that's related to one's economic hardship issues, that they are having difficulty. It's, wasn't known at the time that they acquired F1 status, but afterward they've been having difficulty and they need to work as a result. IIO, that's, internship with an international organization. I won't dwell on these things. And then there's pre-completion optional practical training, which we'll talk about. CPT is far more common than pre-completion OPT. Now, I'm giving you the deadline in this very middle bulletin here. It's basically going into the timeline for when you need to apply for optional practical training. And I don't want to spend too much time on that aspect, but let me know if you all have any questions about applying for it. It's important to be aware of these deadlines, both for OPT and for STEM OPT. So after the graduation, most students, not all students, but most, have a 12-month post-completion OPT that is available for them. That's a 12-month runway to be involved in work authorization that is directly related to the course of study. And then the options from there, many scientists are able to apply for a STEM OPT extension, right? STEM, science, technology, engineering, mathematics. That's right in your wheelhouse. So most of you are eligible for STEM OPT, and it's judged by the CIP code that appears on your I-20. You just match it up with the STEM OPT list, and we'll have up to a 36-month runway of work authorization, right? That's a pretty big, nice, long time to be involved in work that's related to your course of study and gain valuable experience, maybe an employer who's willing to sponsor for you in the future for other benefits. And that's why I also note adjustment of status, change of status to a non-immigrant status, adjustment of status to perhaps a green card process, and maybe some will return to school again to, go up to another level of education, right? Bachelor's to master's, perhaps to PhD. So that's our life cycle. Let's talk a little bit more about these training options that I noted. Especially since many of you are kind of right there in that where you're starting to look at that. Curricular practical training, it's typically after you have one academic year, which is typically 9 months under your belt in your course of study. And unless there's immediate curricular practical training, which can come up if somebody is in a like a graduate level education and the training is required by the curriculum. Okay, so I see that a lot of times in the healthcare space, where certain internships or clerkships or things of that sort are actually required by the curriculum. That could be an immediate CPT option. There is sort of this gray area of, for those of you who have done, maybe bachelor's to your OPT and you went right back to school. You didn't even take a pause. You've been in F1 that entire time. Maybe that first 9 months that you accrued in your bachelor's degree might make you eligible for CPT right away. A lot of that has to do with the comfort of the particular university as well, but it's definitely worth raising. Again, the training, it all has to be related to the field of study. And this is one thing I want you all to be thinking about, is that more than 1 year of full-time optional practical training will end eligibility for more than 1 year of full-time curricular practical training will end OPT eligibility after your program of study. So you want to be very strategic in terms of how you use curricular practical training, just knowing that it could cut down on or remove the training that you receive after the course of study, right? So many of you are going to want that 36 months that you can get after your course of study, and you don't want to unknowingly destroy that opportunity by taking on too much curricular practical training. There's typically a cooperative agreement between the school and the employer, and the CPT has to be required by the curriculum, or at least the student has to receive some credit for it. Optional practical training, we talked, I mentioned pre-completion OPT. It's not as utilized as CPT because it directly draws down post-completion OPT. So you want to be very, very careful about using pre-completion OPT because it could also have that effect of drawing down or possibly even eliminating post-completion OPT. There's even more risk for pre-completion than there is for for CPT, because again, CPT, you can have unlimited part-time CPT, and it's only 1 year or more of full-time CPT that removes your post-completion OPT eligibility. Cap gap extensions, that's basically a way to bridge the gap between the end of the F1 and the start of the cap subject H1B on October 1st. That's the way to bridge that gap. And it is, we can certainly chat more about it if you all have any questions. STEM optional practical training, you have two, you can potentially get up to 2 of these extensions, each with a higher level of education, right? So you can maybe get do your bachelor's degree, get 12 months of post-completion OPT, 24 months of STEM. Go back for your master's, then 12 months of OPT, 24 months of STEM. Okay, so that's how it works, but no more than 2 of those extensions. Another interesting thing is that you can actually get STEM OPT on the basis of a prior STEM degree. And what's interesting about that, well, first, let me give you an example, right? So you have somebody who's maybe bachelor's degree in biochemistry. They do their post-completion OPT, or perhaps they don't. Maybe they just go right to the master's degree. The master's degree is an MBA. It's a non-STEM degree that they have. And afterwards, they do their 12 months of post-completion, but now they would like to also utilize STEM OPT. They may be able to use the, recapture, in a sense, the unused STEM OPT from their biochemistry, that possibility from that biochemistry degree. Now, it's one sort of nugget that I want you all to walk away with is that the CIP codes for STEM have expanded multiple times. 2016, 2020, 2022, and very, very recently with 8 more codes for 2023, for earlier this year. So I'm giving you all the most recent STEM list, but understand that it is not when you completed the degree that is important in terms of qualifying under the STEM list. It is when you apply for STEM OPT. So it may not have been that you chose not to use STEM OPT with that prior degree. Maybe you weren't eligible at that particular time for STEM OPT, but now that degree is eligible for STEM OPT. So you want to go back and you want to look at what was that CIP code. If you're thinking of utilizing it with a future degree, looking back at that CIP code to see maybe it qualifies now, and you might be able to receive STEM OPT. I'm going to move along. 983 training plans, I'll just note, is very important for STEM OPT regarding supervision, compliance, goals, what you will learn, how your education is directly related to the course of study. So it's important to also get your employer involved in this process. And also, employers need to be enrolled in E-Verify for STEM OPT to be a possibility. Let's talk H-1B status, okay? There was a study that was put out by USCIS back in 2019 that analyzed people changing from F1 student status to other non-immigrant statuses between 2008 and 2018. And what they found was that 85% of F1 students changed to an H-1B status. So H-1B status matters. It matters a lot. It is the most common professional worker category, okay? So that's why we're going to address it first. And it requires, it basically involves temporary employment in a specialty occupation. That's a position that requires at least a bachelor's degree or higher in a specific specialty. The employee also must meet the requirements for that particular position and must have all necessary licenses in order to work in that profession. there are certain wage requirements. The employer must pay the greater of the actual wage that it pays to similarly situated workers, or the Department of Labor baseline wage for that particular position and position code. Obviously, there must be an employer to sponsor, and there is a 6-year limitation as well for H-1B status. There are ways to expand those 6 years by hitting certain benchmarks in a green card process. So that is also a possibility to actually get more than 6 years. Now, the numerical caps are a bit of a mess. Okay, so I want you all to be aware of this. I had a few statistics on this one. So it used to be, well, first let me talk about 2004 was the last time that H-1B numbers were updated. 65,000 general numbers and 20,000 for those who have at least a U.S. master's degree. Okay. The numbers ran between 2014 and 2020, those fiscal years. The demand was higher than this supply of 85,000. It was between 124,000 and 236,000 petitions. That's a lot, right? That's already difficult odds. Now, the system changed to this electronic registration process, and it ended up increasing substantially the number of people who applied for H-1Bs because it was easier to at least register. This most recent fiscal year, it got up to 780,884 registrations for 85,000 slots. Now, I want to put that in context for you all because there are two things happening. Number one, there is actual legitimate demand that is, increasing, right? Because there are job shortages across the country, and so there is this increase, this natural increase in individuals who or employers needing H-1B workers, a natural increase. Maybe it's to about 350, 400,000, somewhere around that. It's already pretty high, okay? But how does that take us all the way up to nearly 800,000? That is an issue with the system itself. And it appears that certain employers are actually taking advantage of this system, and there are certain issues that might be happening with employers kind of banding together and filing multiple registrations for the same foreign national, and then the foreign national might get selected and might get something, might get one of these numbers. So that's the issue that appears to be happening and is artificially increasing these numbers. So we have this natural increase, but we also have some kind of improper activity that's happening. Now, USCIS very recently, actually, it might have been in the last few days, they responded to the American Immigration Lawyers Association and said that they have already initiated a lot of investigations. They have revoked certain H-1Bs, and they're also working on modernization rules that would help correct this in the future. So I just want you all to be aware of sort of the current status and situation with the H-1B lottery, and hopefully it'll be corrected over time. This Think Immigration piece, this link here, is an advocacy piece that I wrote about a month or so ago that went into more detail on these particular types of issues. So I want you all to take a look if you want to have more details about the situation. You can find it at that link. J1 status. Let's talk about J's for a bit. So first thing is that a J1 is also, it can be a student category. And there is academic training that's available, just like there's optional practical training available for F1 students. Academic training cannot exceed 18 months at the undergrad or predoctoral level, or the course of study, whichever is less. And for postdoctoral students, it cannot exceed 36 months or the course of study, whichever is less. However, we're going to be talking about this a lot. The Biden administration has put in this STEM guidance, different types of policies to attract STEM students. That's all of you. So definitely you want to be aware. One of them is to increase, one of the policies is to increase academic training up to 36 months for undergrad and predoctoral students. That cap can go even higher, just like it is with postdoctoral students. Now that is a temporary policy. It actually currently expires on December 31st of next year, which means that the academic training must begin by that time. Okay, that's really when the mark is. So some of that academic training will certainly exceed December of next year, and maybe that program will be expanded as well. Research scholars, professors is another common category in the sciences. And it's not just academia, it's, also can include corporate research facilities as well as research institutions. And it's a really nice category. It's allows a 5-year maximum altogether. You want to be aware of repeat participation bars. If you've ever used J1 status before, there's a 12-month bar until you can participate as a research scholar. And also, if you finish one research scholar program, you do have to wait another 24 months before you are engaged in yet another research scholar program. There's also trainees where there is relationship between your degrees and experience abroad and the training you will be doing here in the US. So trainees are kind of different from OPT, right? OPT is always what's directly related to the course of study, referring to the course of study in the US. If you are doing a J1 trainee program, it is the relationship between your course and experience abroad versus the work that you're doing in the US. And it supplies 18 months, an 18-month max. So it helps as sort of a stopgap measure. There is a 2-year home residence requirement that attaches to some J1s. So it is very, very important before you ever get into a J1 status, you want to know what you're getting into and whether you will be subject to the 2-year home residence requirement. And we can talk, if anyone has any questions about that or has questions about J1 waivers, we can address that in the Q&A. O1 status is a status for those who have extraordinary ability in various areas, including the sciences. We use them for sciences, research, scientists, researchers, physicians, business professionals, etc. And it is very different from the H-1B in the sense that there are no wage requirements, no caps. You can get O1 status for 3 years. You can renew indefinitely for periods between 1 and 3 years. So it's an excellent status if you qualify. You do need a U.S. employer to sponsor. It does say agent, but agents are usually for performers and others. It's usually for a scientist, they would actually have a U.S. employer, like a lab, like private employer, etc. There are different types of criteria, with respect to O1 status that you need to keep in mind. You have to meet about 3 out of 8 criteria, and then there's an overall merits determination as well. And so it's usually centers on critical and essential role that one had, original contributions in their particular field, scholarly articles. Have they done any peer review or other judge participate as a judge of the work of others? Do they have a high salary relative to others? Those are some of the items that are most significant for the O1. I will note that the Biden STEM provisions do extend also to O1 status. They provided very helpful clarifications in the USCIS policy manual to help explain what each of these categories meant from a STEM capacity. So they even mentioned about, for example, national or international awards. If you have received an award from an R1 or R2 university, for example, that might qualify as a national or international award. So these clarifications are helpful because they were made with the intent of attracting STEM workers. Yeah, go ahead.
Adam, so you mentioned a lot of numbers on H1B, and
Yes.
you also mentioned 85% of F1 visa holders usually transition into the H1B. But it seems like it's getting pretty competitive at this point, right? And
Yes.
with the system not really functioning properly, this might not be the best way to go. Do you have similar numbers on the O1? Like how many are awarded? Is there a set cap or is it kind of free floating? Like
Yeah.
what are someone's obviously very generally, but like how likely is it to get an O1 if you think you qualify for a few of the points?
Yeah, that's a great question, Oscar. And I suddenly realized as I was going through this that I didn't talk about H-1B cap exemption. So I want to answer your question first, and then I want to talk about other aspects of the H-1B that I think are important. So the first thing is, I think that there are numbers out there. I do not have them with me right now for O1s, but USCIS does typically put out reports because I know they do them for green cards, and I believe they do them for H-1B status as well, just approval rates. On their page, they do have a reports tab. I think there's sort of like a reading room area, and then there's a reports tab, and you can do a search for different types of tabs. I think they might even have a report just for non-immigrant statuses alone. So we can definitely connect about that, Oscar. But yes, there should be. Now they don't keep they don't keep all of the data. They don't necessarily have it broken down by industry or things of that sort. But I think that they must have just approval rates generally. What I like to look at when it comes to O1s is I'm looking at metrics. Okay, so when I first talk to prospective clients, I'm asking them if they have primarily in research, how many citations do you have, through maybe Google Scholar or ResearchGate? That gives some indication of standing in the field. Of course, it doesn't tell the full story, but that's a lot of the things that USCIS is looking at. If you have any prestigious awards, what were the criteria for that awards? How many people applied for those, and how many people were accepted? How much grant funding have you been involved in a PI, co-PI, or other key significant role as part of the grant project, right? Like how much money in terms of funding. So those are all things that I think can help a lot, those metrics. And ultimately, it tends to be sort of a story that we're basically developing around this individual, where it's not just, putting metrics on a page, it's writing a whole, crafting a cover letter that goes into, the person's impact and contributions, letters of support that talk about, have anecdotes about things that person has done, ways that they've disrupted the field in certain ways for the good. So those are some things I would mention to you all. I want to mention for cap exemption, because I don't want you to all to think that it's all about the H-1B numbers. There are certain ways around these numbers. They are, if you are employed by or employed at an institution of higher education, a nonprofit affiliated with an institution of higher education, or a nonprofit or government research organization. And that can be employment by, that's the most common one. By is like, nonprofit hospital system, that has affiliations with institutions of higher ed, is hiring a medical technologist, right? That's like a cap exempt H-1B a lot of times. But it's also can be placement at, right? So it could be some type of, could be an IT staffing company that is, private company, but is placing that individual for a majority of the time at a cap exempt location. Those are two sort of iterations. There are a few, there's another one where you have two H-1Bs. So you have a private company, you're going to be working at a, maybe like a biotech startup, and you're being hired for this H-1B, but you also have a relationship with a university. Maybe you're able to get an adjunct instructor position where they're willing to file a cap exempt H-1B for you. You get that approved, and then your biotech startup files an H-1B for you, right? You hold two H-1Bs, you hold concurrent H-1Bs, and you receive the umbrella of cap exemption supplied by the university's part-time adjunct H for you. Okay, so there are a few ways to make that work as well. I'm going to move on ahead to the next topic, which is TN status. And we talked about that just for Canadians and Mexicans, in a qualifying US-Mexico-Canada agreement position, because the USMCA superseded NAFTA, but it didn't really change the TN categories. It's unlike the H-1B where, any professional occupation may qualify, right? If it requires at least a bachelor's degree in a specific specialty. For TN status, they gave the list and they said, you must be on this list if you want TN status. But there are so many scientist codes They have engineers and mathematicians. They have a specific scientist section with biochemists, pharmacologists, physicists, and others. They also have technology, computer systems analysts. They have teachers, for those who are teachers in the sciences, right? You also have to meet the credentials on that list of what, on the TN list, what degrees or experience you need to be able to qualify for that position. And it's not really a self-employment situation. You have to have an employer in the US. But again, it also doesn't have any of these caps or lengths of time that you need to have in a TN. You can keep renewing, and no wage requirements for that either. E2 status it's a treaty investor status. There has to be a treaty of commerce between the United States and that particular country. Okay, so E2 status is more governed by Department of State, because the Department of State is involved in foreign agreements, right, or agreements between foreign entities and the U.S. government. So a lot of people get E2 status through the embassy, but some will also change status within the U.S. to an E2 status. They just need to know that when they travel and they want to get an E2 visa to come back, the Department of State is going to re-adjudicate that entire E2 scenario. This investment, it has to be a substantial investment, which really is relative to the particular type of business, right? Is this a brick and mortar business? Is this an online business? That certainly affects what is necessary in terms of startup costs for the business and what is considered a substantial investment in that business. There has to be a business plan, typically, with establishing growth realizable over about 5 years. And the business it can't be a marginal business. It has to somehow help the US economy and not just help the individual or the individual's family support themselves, right? So, maybe it's creating jobs in the US. Maybe there are contracts with US vendors through that business. So other companies benefit, the community benefits. So that's our E2 status. And L1 status is an intracompany transferee. So it's somebody who is being transferred by an entity abroad to an entity in the US, right? You have to be working 1 out of the last 3 years at the related entity abroad, which is kind of why it makes it, not quite as desirable for those who are here in F1 status. They want to go on to working in the US a lot of times, but it can be a way around the H-1B lottery by sort of establishing that pipeline. If there's a relationship between that US company and a qualifying entity, or a relationship with that entity abroad, you might be able to work there for 1 year and be transferred in a managerial or specialized knowledge capacity back into the US. Okay, so L1 can be a possibility too. A lot of we're like talking about the H-1B, and we're talking about the difficulty of the numbers, and then we're talking about other types of statuses here that might be workable, that should be considered as a way around that H-1B lottery. Okay, so I think we only have a few more slides, and then we're going to open it up to questions. So green card options. We have the big priority workers ones, like extraordinary ability green cards and outstanding researchers or professors. Extraordinary ability is a self-petitioned green card. And you have to meet 3 out of 10 criteria, and there's an overall merits determination. It's similar. It's sort of the green card version of an O1, but it doesn't mean that if you get O1, you will definitely get EB1. It doesn't quite work that way, but it's similar in that sense. It's typically self-petitioned. It goes across all industries, so it provides a lot of flexibility where one qualifies. Researchers or professors, a lot of times that's within academia, but not necessarily. You could have a research department for a private employer that has 3 full-time researchers, not including the foreign national, and has a lot of accolades in the particular field that research department does, and they may be able to sponsor for an outstanding researcher type of position. Okay, so it could be open. The researcher position has to be of unlimited duration. So it's got to be more or less a permanent type of position for the researcher. We drop down into employment-based second preference, and we get to the perm process I alluded to earlier. That's where Department of Labor is involved. You have to show that there is no minimally qualified U.S. worker for that position. There is a sort of variation on that in academia if you're going into a teaching position. So we can talk about that if there are any questions. And then I definitely want to flag for you, I'd be remiss not to mention the national interest waiver, because the Biden administration actually has some STEM policies surrounding the NIW green card. It's also a self-petition process. In most cases, we do them a lot of times for, we do them for students, we do them for postdoc researchers, we do them for early career physicians, we do them for entrepreneurs. There's a lot of options with this type of green card process. And there's 3 prongs to it. So first you have to show that you are going to be involved in an endeavor that is of national importance and substantial merit. Okay. So that can include, I was trying to segment out a few of these things for you all. Thinking about maybe like the research and development priorities of the Biden administration, for example, critical and emerging technologies, things that are important to U.S. competitiveness or national security, right? There's a second prong, which, takes the light that's shining on the endeavor itself and turns it back onto you and asks, are you well positioned to advance that field of endeavor? And I'll note for you all that actually having an advanced degree in a STEM field, especially a PhD, is I want to get the wording right, especially positive factor for the NIW, though a degree alone will not satisfy that prong. So it's helpful to have other things, certain awards and, publications with maybe a good citation record. And then the third part is really more of a balancing act between the interests of the U.S. by the work that you are doing versus the interests of the American worker, which is the perm process itself, right? The perm process is vetting the job opportunity to U.S. workers. So if that process is being waived through the national interest waiver, your endeavor has to be pretty important. And again, issues like U.S. Competitiveness are, STEM work that is important for U.S. competitiveness, critical and emerging technologies could all be very important to that end. And I'll also say on that third prong, the impracticality of a perm process is important too. What if you're a postdoc researcher? Most of the time you won't be sponsored by the university. They don't sponsor those types of positions commonly. So it's impractical, but you might be doing very important work such that, you would do better with a national interest waiver. So just something to think about. There's, of course, marriage to a U.S. citizen as a process. Diversity visa lottery is a process where there's 50,000 numbers that are available annually through a lottery, and it's drawn among individuals who are from countries with low rates of immigration to the United States, and it is truly a lottery. Now, the runway, you've all heard me use this word before, and I was mentioning it in the context of optional practical training and academic training. If you can get 36 months of OPT, you get 36 months of academic training if you're in J1. That's a lot of time to finalize a green card process. Okay, so sometimes people will have a green card process started and also get their several bites at the apple, as I say, of the H-1B lottery each year, because sometimes you need that many tries, right? And you still have this work authorization all along. So it's important to make good use of that practical training. Now, there is a weird phenomenon right now, this EB2 retrogression that's happening, and it all has to do with supply of immigrant visas and demand, okay? So not unlike the H-1B in a sense, but supply and demand are making these green card processes take a lot longer because it is being artificially regulated by the Department of State to kind of stem the surge in demand and make it more attuned to what's actually reasonably available through the supply. So there are artificial restrictions that Department of State puts in, and it's making things take a lot longer. So that also has to be considered alongside that runway supplied by the OPT and the academic training. Oscar, do I have a few moments to talk about entrepreneurs before we get to questions? Or
yeah, I think there's a question in the Q&A section though related to the last slide. So you could.
Oh, great. Okay. Yeah.
So it has to do. If you go back to the previous slide, I think the researcher position you alluded to in the EB1B, I think.
Yes.
Can that also be related to working at a state agency where the research and analysis for technology that benefit the state is the type of work that is being performed? Basically, I think it's assessment or analysis of various technologies that might benefit the US.
Yeah.
That's the kind of work being done at a state agency. Would that possibly be covered under an EB1B green card option?
Possibly. I'd have to look at that. You know, a lot of times it's I think of it in terms of, you know, academia. I can actually look that up as we're going through some of the Q&A, but it's typically it's institutions of higher education, or it's you know, I believe, you know, certain laboratories, right?
Right.
National laboratories. Maybe that's what we're kind of talking about here. Or private employers, if, you know, if there's an established research department.
Yeah. So I think it might have been the national laboratories that might have been what triggered the question. And so, but I from my understanding, national laboratory, if you are a foreign national, get some kind of employment there, this is an option, right?
Yes, it is. It is. We've done those before, actually, with different laboratories as well. And it is, you know, it's something that's has to be sponsored by the employer for an EB1B. But the EB1A can be self-petitioned and typically is.
Yeah. If I didn't ask that question properly, you have to just let us know and we can take another stab at it. Thank you.
Definitely. Okay. So the last slide, you know, the first thing I'll mention to you all is, so we have an attorney at our office, Jason Susser, who really is, you know, he's the person to speak with when it comes to startup immigration and entrepreneurs. You know, he works with a lot of startups every year, so he can comment a lot more on those types of considerations. But I want to flag for you all the basics, and I want to get that stirring in your mind. If you are an entrepreneur, or if you're thinking of starting your own business in the sciences, for example, there are different statuses. Some of this may have already resonated with you as we've been talking about these different categories. You know, F1 status, optional practical training is, you know, great training for starting up a business, as long as it is directly related to your field of study. STEM optional practical training becomes a little bit more difficult because, again, the company has to be E-Verify enrolled, and you know, there are different compliance aspects to it too, right? So you can't sign your own 983 training plan. Maybe if you had a co-owner that would be able to provide you with certain training and supervision, then it would be workable to you know, be involved in your business and have ownership interest and still be able to acquire STEM OPT. It sort of skirts a line, but I think there's a way to thread that needle to obtain STEM OPT. H-1Bs can be done even for sole proprietors. It's certainly a lot more difficult. It does involve an employer-employee relationship, which means that there has to be appropriate control exercised. And usually for our sole proprietors, there's maybe some type of outside board of directors that is exerting control over the business. E2s, figure you all, you know, was sort of already thinking about that, right? Because a lot of times, you know, for entrepreneurs, it's something that's investment-based or it's role-based, right? So the investment-based is E2. Some of you have heard about EB5, investor-based green cards, for example. Entrepreneurial parole, which we'll chat about briefly, is also investment-based. And then you have some of these other processes that are more role-driven or ability-driven, like H-1B status, O-1 status, L1A status. L1A is a lot of times somebody has let's say they have an entity abroad, it's their entity, and they are actually transferring themselves from abroad to a new entity that they form in the US. That's a possible L1A as well, right? If they're coming as a manager. And yeah, so other types of green cards like NIWs, EB1s, for example. I meant to put a comma between L1A and green card, different items. So there are different policies, just as there are for STEM workers, there are NIW policies that are specific and favorable to entrepreneurs, right? So, prong one, endeavor of national importance and substantial merit. They look at significant potential to employ US workers. Prong two, having venture capital or grant funding can show that you're well positioned to advance the endeavor. Prong three, that balancing test, right? Somebody who has the potential to generate revenue consistent with economic revitalization, potential job creation. Okay, so there are very good policies available for STEM professionals, available for entrepreneurs. If you're a STEM professional entrepreneur, even more so, right? So I want to show you all, there's this link as well, Pathways for Entrepreneurs. That's also available on USCIS's website. It's going to cover a lot of the things that we're talking about too. Finally, I want to mention to you all, entrepreneurial parole. It's kind of been a bit of a unicorn in immigration because we've had some, I know my colleagues filed some, and it's just kind of sat. But now they're developing more policies around it, and hopefully they want to really make it a viable mechanism for entrepreneurs. It does involve having a substantial ownership interest in a startup that was created in the past 5 years that has potential for rapid growth. Okay, so what's a substantial ownership interest? About at least 10% ownership initially. What is rapid growth? Possibly receipt of venture capital, significant venture capital or grant funding. You have to have a central role and be well positioned to substantially grow the business. Sounds kind of similar to NIWs actually, but having that role, being able to grow the business and providing a significant public benefit to the United States are all considerations for entrepreneurial parole. So that's sort of some of the basics of startup immigration. This is a handbook that our firm has put out, and this is my email address below. If any of you need to reach out, you can schedule a consultation with me. If you're in the startup world, you can schedule a consultation with my colleague, Jason Susser. If you're not really sure, if you have questions more about like humanitarian status, just shoot me an email and I can tell you who to chat with. But that's everything from me right now. So I want to still be able to turn it over to questions. We have a good 25 or more minutes right now to kind of address any questions that are on your mind.
Yeah, thank you so much, Adam.
Sure.
I think I have a lot of questions, but maybe I'll take them with you later. I guess there was alluding to the previous question, yes, it could be a national laboratory, but they're also given examples of like California Energy Commission or natural resource agencies. I don't know if you had anything else to add to that.
That's a good question. I was going to just kind of look and see how it says it in the particular rules for that. Let me see. I think it's this, so I could be a little bit more precise. Yeah, I mean, because and you should also note there's a discrepancy between professors and researchers, right? Like professors are at U.S. universities or institutions of higher education, and they have that tenure or tenure track position. It's the researchers that's a more sort of flexible type of more flexible employer. So they say it has to be a institution of higher education or a department, division, or institute of a private employer. Okay, that employs at least 3 full-time researchers, etc. So that's what I understand it to be. Also, we've done it for institutions of higher ed. We have done it for national laboratories. So I would imagine if it may function if it's not a university. it may function the same way as a private employer, I think. I'm not 100% certain, but I think it should work just fine, right? Just like it would for, a private company that has a research department. There's no reason that a state agency that has a research department, or a national laboratory that obviously has a research department, could not sponsor somebody for EB1B. They probably, if they're sponsoring you, and you're working as a researcher, they probably have at least 3 full-time researchers, and not including you, and they probably have some accolades and some successes as being in research. So I imagine that would be that's my thought process in terms of how they're qualifying.
All right. Yeah. I hope that answers the question fully. Another one we have here is related to J2 dependents.
Sure.
Can they work while applying for an EB2 national interest waiver status?
Yeah, can a J2 work while they're applying for an NIW? Yeah, I mean, J2s are permitted to work, just sort of inherent to the J2 category, right? You can acquire general work authorization as a J2 dependent, as long as that there's a rule about that income that you're getting from the work is not supposed to be able to support everybody, right? Like the J1 is supposed to be the primary source of that income and support. But apart from that, yeah, J2s have general work authorization. And the fact that they have an NIW pending does not change that ability to get work authorization. In fact, NIW green card process is broken into 2 pieces: I-140 petition, I-485 adjustment application. With that adjustment application, you can file for an application for work authorization as well. So, one can also have not just the J2 work authorization, but you could alternatively have work authorization, through the pending adjustment application. It's always important to talk to somebody, talk to an immigration attorney before you start using that EAD, through the green card process. But yes, the short answer to the question is yes, you can work. You do have to be careful. I will say this, Oscar, though, because the question that hasn't been asked, but maybe should be asked, is, can I travel internationally while I have this green card process pending and come back on my J2 status, right? That's a problem. That's a problem. Some of these statuses are not dual intent. F1 is not dual intent. B1 is not dual intent. J1 is not dual intent. That means that every time you come into the US in those statuses, the CBP officer is evaluating, or the Department of State, if you're getting a visa, they're evaluating whether you intend to immigrate permanently to the United States. Okay, so if you have an I-140 green card petition out there, that's a problem. If you have a 485 adjustment application pending, you can actually abandon that 485 if you travel without advance parole through that green card process. So there are a few different ways where international travel in one of those statuses does not play nicely with the green card and could actually prevent you from being able to enter the US again, while that green card process is pending and you're coming on that J or F status, right? And it can also be a problem for the green card process itself and its ultimate approvability.
Yeah, I think now I understand why. I was always wondering why that was, but yeah, it makes a lot of sense if that's very clear intent to stay or intent to immigrate.
Right. Whereas, you could have somebody who's like still here in the US and they have a green card process going, but I always tell them, don't travel internationally if you're going to do that.
Yeah. I guess I had an interesting question to people who are about to graduate or
Sure.
coming up on graduation, right? I plan to apply for STEM or OPT and then STEM OPT extension, at least initially, right? Unless I guess there's an opportunity to go in some kind of startup route, in which case you have to assess all sorts of other opportunities, right? What can you say to? I'm currently on F1, but a lot of people are on F1 or J1. until you have that next step secured and maybe have begun the conversations with your employer about starting an OPT, it's best to maintain your F1 status. Um, in terms of planning of your graduation, how should international students think to avoid running into a situation where you're just not covered under any status, but you plan to start something? You also mentioned some cap gap
Mhm.
extension.
Right, right. Yeah, I mean, if you know if you're planning to apply for OPT or for STEM OPT, you're still in F1 status, right? So you're still maintaining a valid record. So it's not really disrupting your F1 status, right? By being involved in OPT or STEM OPT. I have seen unfortunate situations, where people transfer their program to like another university, and when they do that, they actually like cut the OPT or STEM OPT down, because it's tied to a particular university and they've transferred from that university. I've also seen students who miss these deadlines, these extremely unforgiving deadlines for applying for OPT and for STEM OPT. I think it's important, certainly if somebody is planning to apply for H-1B, for example, that they maintain their F1 status, that they apply for that OPT, that they apply for that STEM OPT, just to keep that process going, right? And they're doing it according to all the necessary deadlines, even while they're putting in for those H-1B registrations, right? It is very important to keep that status going. And I would say it's the same thing for for J1. The cap gap extensions, they're not necessary initially. They're really more for the very last year of your OPT, right? So if you're going OPT to STEM OPT, it's not really a cap gap situation until you get to the end of that STEM OPT, right? And that STEM OPT ends in, let's say May of a particular year. And you file, let's see, I think you get selected in early April. So if you get selected in the H-1B lottery in April, you need to file that H-1B petition as a change of status from F to H-1B prior to the end of your OPT or your STEM OPT, right? And that's how you are bridging the gap through that timely filed petition for change of status to H-1B. You're bridging the gap until October 1st for your work authorization. Okay, so like when I count how many bites of the apple can somebody get at the H-1B, I'm counting all of their time in OPT, and I'm looking at the cap gap situation as well, right? But when you get to that last year, you have to be careful. I mean, and some people can't get cap gap that last year because maybe they, graduate in February, and so their OPT then ends in February, 1 to 3 years down the road, right? And so they're actually out of the OPT by the time that they could actually file for for an H-1B petition. And they'd either be in a grace period, F1 grace period, which would allow them to maintain their status, but they would not have the work authorization, or they graduated so early, like in the fall instead of the spring, that they just don't have even the opportunity to maintain their F1 status through that period of time. And then you also have J1 students who don't have cap gap. It's not available to them. It was never implemented in regulations. So they sometimes do have to leave the U.S. and then come back in H-1B status, or maybe they get selected while they're still in the academic training period, and they're able to transition to H-1B status, prior to using up that academic training.
Yeah, it seems like as long as you have a plan, you can navigate the system, but it's when you're trying to do things last minute that it's not very forgiving in that sense, right? Where it's like, oh,
Oh,
well, for you, we
100%.
can make an exception.
Yeah, I mean, I totally agree, Oscar. That's why it's so good for us to, just kind of have this conversation and for you all to think about it. It's like if you have all of the information, you can typically make a decision, right? I think all of you can do that, but you just need to be aware of it, and it's not always forthcoming, right? You may be at your university and you're learning a lot of things about maintaining your F1 status, but a lot of times the school only knows so much about the next steps, or only feels comfortable advising you so much about next steps, right? Because it's not really in their wheelhouse, or it brings certain liability onto them to provide you incorrect information about how to proceed from there. So you're getting things in little segments, but it doesn't help you for transition points.
Yeah, so let's see. We had a lot of Q&A pop up here. I'll try to. I think you can also see the Q&A window, right? In case.
It's interesting. I see the Q&A window, but well, let me see here. Oh, actually, you know what? I think I had the wrong box open. Okay, I see it now.
All
I
right.
think I had the chat. I had the chat open.
Yeah. All
Yeah.
right. So first question, and PhD students about to defend, and they don't have a job offer lined up yet, which is kind of the situation I was talking about, right? Like,
Mhm.
how do you do that? Do you want to prolong your PhD defense until you find a job, or they're planning to apply for the F1 OPT in a manner to maximize their grace period, and so they're curious about what counts as unpaid volunteering as a STEM PhD. I guess how you can utilize unpaid volunteering or volunteer work in
Yeah.
your grace period OPT applications, all of that.
Yeah. I mean, are we talking about unpaid volunteering through OPT? Because that's certainly allowed, right? I mean, I don't think this isn't necessarily a question where we're talking about what constitutes work, right, for purposes of maintaining one's F1 status. Because if you apply for the F1 OPT, right, and you're concerned, look, I want to maximize this. I don't want to start accruing unemployment time when I'm getting right into my OPT, because 90 days later, that's the end of my OPT. I'm out of status, right? So I need to have some kind of job um, that so that I'm not accruing unemployment time, and that's definitely something that you want to think about. And it's pretty wide open for OPT. It can be unpaid, and it just needs to be directly related to the course of study, and keep good records of your job. Okay, keep records of maybe emails, something that shows that you've completed work product, offer letters and things of that sort. Because when it gets questioned later, which doesn't regularly, but let's say there was something questionable about that employer later down the road, and USCIS is asking, show you maintained your status, where are your pay stubs? And you say, well, I don't have pay stubs. This was an unpaid, position that was directly related to the course of study. If you have record that you were completing certain work product and things of that sort, that the job actually existed, that's a helpful way to get around that situation. So it can be a lot of different activities as long as it's related to the course of study. So if I understand the question correctly, Oscar, I think we're talking about unpaid work performed during the OPT period, and that's okay.
Yeah. I guess same. Like an add-on to that question.
Sure.
They're asking about the 60-day grace period.
Yeah.
When does that start after your defense? It says, is it my defense date or my graduation date per I-20? I would imagine it's I-20, right? Because the government doesn't really follow along and see when you actually defend or not.
Yeah, I believe it is all dictated by the I-20 itself. Okay, so if I remember correctly, I know you can at least do this in the J1 side. I think you can in the F1. Like if you graduate earlier than expected, it is possible for the DSO to go in and shorten your course. They're actually shortening it in the CVIS system, but really it's all dictated by CVIS. Okay, so you want to make sure you're in touch with the DSO at your university about that, so that that's sort of where there's an intersection, right, between the DSO and the immigration attorney, right? Because they're the ones that see the CVIS system, they're the ones that monitor it, they're the ones that put actions into it. But yeah, I believe it is all dictated by the I-20.
Yeah, and I think you can get in contact with your university in case when you start a PhD program, you should say expected, anticipated graduation dates and everything. Those can be changed if needed. I personally plan to just kind of lean on the safe side of things. There's some other questions. could you please explain about the J1 2-year return and waiver? How
Yeah,
does this handicap getting how does this handicap getting other kinds of visa, H1B, or applying for an EB to NIW?
sure. So I will say, there's usually a presentation in and of itself, but I'm going to say a couple things about the J1 because we deal with these a lot. So, how do you get subject to the J1? You get subject because you have received U.S. government, which is the worst, U.S. government funding, or home country funding for your J1, or you uh, you're involved in a program uh, where you are acquiring skills that are very much needed by your home country. They call that the exchange visitor skills list, and it's also determined by the subject code on your DS 2019 and matching that up with the exchange visitor skills list. Okay, so those are the primary ways. There's another way. All doctors, all medical doctors coming for clinical training are automatically subject, but for everyone else, it is skills list or government funding. What does it prohibit? It prohibits you from acquiring H status, an H visa specifically. You can't get an L visa. You can't get a K fiance visa. You can't get a green card, and you cannot change to most other statuses within the U.S. Okay, so what can you do? You can leave. You can come back in an F1. You can leave. You can come back on an O1. You can, there are certain things that you can do, but yes, it is an elephant in the room, a monkey on the back, whatever you want to call it. It does make things more difficult until it is dealt with. How is it dealt with? You can deal with it by satisfying it. So going home for 2 years, it doesn't have to be continuous. It can be done in chunks of time to satisfy the 2 years, or it can be waived. For non-doctors, the most common way to waive is called a no objection waiver from the individual's home country. So the home country says, we do not have any objection to this person returning, or not returning to the US, I mean to say, and they forward that information to the Department of State and ultimately get the waiver approved that way. There are other types of, any federal agency can potentially sponsor a waiver, but a lot of these are very cumbersome. The rules aren't very solid and set. There are also hardship and persecution waivers as well, but definitely the most common waivers and no objection waiver. So that is J1 waivers in a nutshell.
Perfect. Yeah, I think you have time for 2 more questions, maybe, and then
Sure. Yeah.
wrap it up. So I think we've touched on this, but I guess there's so many acronyms and people get confused.
Mhm.
If you're applying for a national interest waiver green card while on a STEM OPT, will that affect your STEM OPT status in any way?
No, it will not. And actually, it's a great question, and it was actually one that was raised directly to USCIS. And USCIS gave an answer that is very much in line with my understanding and the case law on the matter, right? That you can both have F1 and have a green card process going in the US, within the US. It's the international travel that's the problem, right? But while you're here, as long as you're doing everything you need to do to maintain F1 status, working on OPT that's directly related to your course of study, or being in a course of study and you're meeting the definition of full course of study, then you are maintaining your F1, and there should be no reason that you should be kicked off of your proper maintenance of your status, including your work authorization. Okay, so the answer to that is no.
Yeah, it only affects travel. Don't try to leave the country. All
right.
Last question. It's probably going to get convoluted if I try to read it. So if you want to check out and read it yourself,
sure. Yeah,
right.
Let's see. So J1 2-year residence requirement. If an individual is subject on the basis of country A, but before that individual fulfills that requirement, they have changed their citizenship to country B. In that case, is the individual still subject to the home residence requirement of country A? If so, how to fulfill that 2-year after change of citizenship? Ooh, yeah. That's a meaty one there. So the best way to deal with this is with a J1 waiver, because the J1 waiver will typically, unless there's some US government funding or something wonky like that, it should take care of those 2 periods of being subject. Otherwise, I would think that that person would have an obligation to both. I don't know how they would otherwise deal with it, because if, they say that, impossibility of performance maybe can be a grounds for not satisfying something, but you chose the citizenship, right? It's kind of like the individual, like the classic scenario here is like the individual, or at least the one I think of as classic, the individual who, who had Indian nationality, acquired Canadian citizenship, and lost the Indian citizenship as a result. But before they acquired Canadian citizenship, they were in the US on a subject J1. In that situation, you still have an obligation to satisfy in India, even though you have citizenship in Canada, because you chose the citizenship. So I think, and this is kind of going a second step, right? Which is then saying, then the Canadian goes, now you have Canadian citizenship. So then you go and you get a J1 after that. I think you'd have to satisfy both periods in that situation, because I don't know how you get away. That's a very niche type of issue, but I don't know how you handle the issue of you need to satisfy in this country, not this country. So you can only satisfy in the home country. So I think you'd have to satisfy in both, but I would say get a waiver. You'd really want to get a J1 waiver in that situation. Yeah, that's
Yeah,
a tricky one too.
I'm happy you took that one because I couldn't really understand the question either.
Yeah. And then it's like, do you get it? Where do you get the no objection waiver from? Also, that's another. I'd really have to think through that one.
Yeah, please. If you have more specific questions like this, easily get in touch with Adam, and he can put you in touch with whoever is an expert at Suskin or deal with himself.